Thank you. Good afternoon. This is the House Committee on General and Housing. And today is still January 29, 2025, and we are back in session for the afternoon. First, we're going to hear from Angela Zajkowski, who is Director of the Vermont Landlord Association. And then at 2, Big Hartman, the Executive Director and General Counsel of the Human Rights Commission, is going to join us, I think in person, and talk about the Human Rights Commission generally. And then at 3 o'clock, we have the floor. So that's our afternoon, everyone. So I'll tell you what, why don't we introduce ourselves to Angela, who is joining us via video. Welcome.
Thank you.
You want to start off?
I will. Good afternoon, Claudia Lamont, representing the Moyle Washington District, Morristown, Elmore, Worcester, Woodbury, and a small part of Stowe.
Hi, Angela. Mary Howard, Rutland City, District 6.
Good afternoon, Gail Pezzo, Chittenden 20, Colchester.
Hi, Tom Charlton, Chester, Athens, Wyndham, and Grafton.
Joe Parsons, Newberry, Topsom, and Groton.
Leonora Dodge, Essex Town, and the City of Essex Junction.
Hi, Angela. Ashley Bartley, Fairfax, in Georgia.
Welcome, Angela. I'm Mark Mahaly. I represent Calais, Plainfield, and Marshfield. And several of the committee are out because, unfortunately, the flu and pneumonia is going around. I think a number of us are still fighting it off or have experienced it. So, would you please introduce yourself for the record and tell us what you want to tell us?
Sure, absolutely. Thank you for the invitation today. My name is Angela Zajkowski. I am the director of the Vermont Landlords Association. We're a statewide trade organization for housing providers. I'm also a practicing attorney, and I have private practice where I represent housing providers primarily in eviction actions, which gives me sort of a unique perspective, I think, on what we're seeing out with this relationship, particularly when it breaks down. I think it's important for the committee to have some sort of background information. We don't have a rental registry here. I understand you've heard some folks pleading the case for that, but the best guess that we have is that we have about 75,000 to 76,000 rental units in the state of Vermont. And that we know in 2024, at least through the end of October, there were a little bit over 1,800 evictions, court evictions. So, you know, in terms of numbers, this is sort of what we're looking at and with a problem in terms of a problem or not.
Is that, Angela, is that 1,800 evictions that went to court or just 1,800 tenants who got eviction notices and may have evicted, just left?
Right. So those are court statistics because that's the one thing that we do have. We don't have a way to track how many tenants receive termination notices and then take action based on the receipt of that notice. We only have the ability to track what gets filed with the court because it's public record. So there is potentially tenants who receive those notices and take action based on that notice. I do understand sometimes people refer to that as an illegal eviction. It's not. You know, landlords send tenants termination notices, and if they act on it, they act on it. If the tenant does not act on it, then the landlord, really the only option is to enforce that notice with a court process. So that's sort of the two-step method of how Vermont handles the exit or the request to exit a rental property. I will say for the committee, the last 5 years for housing providers has been very long and very rough. We had 18 months of an eviction moratorium during this time frame, which meant tenants could not be evicted for not paying their rent. They couldn't be evicted for most violations of the lease. There were a few sort of very extreme categories where tenants could still be removed, but those were sort of the exception. And very few cases were filed or were able to be pursued during that time frame. Housing providers have seen unprecedented increases in costs between property taxes, repair costs, and one of the unintended consequences of the cost of goods going up, the cost of labor going up, is that insurance costs have also increased greatly. Most insurance policies are on a replacement cost value, so that's what your premium's based on. So the more expensive it is to replace a building, the more expensive your premiums become for insurance. So we've sort of seen everything rising and increasing. That being said, we've also seen sort of unfathomable levels of rental assistance in the state, and tenants and landlords have had access to large sums of money. A number of tenancies have been redeemed over the past 5 years, which means tenants have had access to money to pay back rent, to stay in their housing. But all of these programs sort of came to a very abrupt end in 2022. And so then what we've seen is when these programs stopped, we were sort of back where we were prior to COVID, which is a large number of tenants who don't have an ability to pay their rent, landlords who are navigating a process which post-pandemic is almost twice as long for an eviction as it was prior to the pandemic. And so along with housing crisis where tenants can't find places to go because we don't have enough units in the state. So we've sort of have this like perfect storm of all of these things. And what I can tell you the housing provider community is feeling right now is that the finger is being pointed at them, that this is somehow all their fault, that they're increasing rents, that they're having to evict tenants, that they're making choices about who they're going to rent to, and that proposals are being considered, things like just cause proposals, rent control proposals that feel very much like a punishment for landlords who are here offering a service, providing housing, and not feeling like they get a huge amount of support from the state in return. And so with that sense, whether it's right or wrong or true, this is what the community is reporting back to me, is that we've seen a lot of landlords getting out of the business. We're seeing single family homes that were once rentals being sold. We're seeing properties in some instances sitting vacant because landlords would prefer to not rent a property versus having to deal with a tenant or a rental situation. And so from the landlord community, they're asking for some relief and some help. There's a few things that I think could make some good strides or some good help for landlords. One of them is what I refer to as the Decker Towers issue. And you may hear from the folks related to Decker Towers. Decker Towers is a property in Burlington. And what has happened at that property is a tenant in a unit will get evicted, sometimes for drugs, sometimes for other activities. And then when that tenant is evicted out of that unit, they'll move into a neighbor's unit. And under the law, that's allowed. And now the landlord has to evict that next unit. And then that unit gets evicted and those people move into another unit in the building. And the reason why we have this problem in the housing field is because there's a Supreme Court case called State v. April Dixon, and I'm happy to provide it for the committee if you'd like it. I believe it was from the 80s, that says even if a landlord has a writ of possession against a tenant, or against a person or a property, if that person is being invited back onto the property by another resident in that building, it's not considered a trespass. And the landlord just has to keep evicting people in order to deal with that situation. So we have tenants who landlords are going through a process to evict out of a property, who are then not prohibited from coming back onto that property because they're being invited by another resident that lives there. So I think, there's some small places like that that I think would have a big impact and could really help with some of the issues that I've been hearing about from my housing provider, my housing providers around the state. I think those are all the formal comments that I had prepared. I'm happy to take questions or have a conversation or explain anything more of what I have said.
Go ahead, Ashley.
Thank you. If you could send something on the state v. April Dixon is what you said?
Yes.
That'd be really beneficial. I just have a question about, from my understanding of landlord tenant, a landlord in a lease, in a contracted lease can say, you can only have, one tenant, one person living here. Is that what's going on in the Decker Tower situation?
So you can have that in your lease.
Mhm.
For landlords, the only remedy is an eviction. So
So they're
if,
just inviting somebody in and letting them. Okay.
Yeah.
So it's not like a formal, they're moving in, it's just they're letting their doors open to.
I think it, so Decker Towers, that's not a client of mine. The
Mhm.
information I have is newspapers and conversations with folks who are involved in some of those situations. It was a combination of both. So it was people coming to visit that were causing problems that had been evicted, but also tenants who had been evicted were literally moving into other units in that building. And yes, that's a violation of the tenant who invited them in of their lease, but the landlord's remedy to deal with that is an eviction. That's the only remedy that's available to the landlord.
And that's not happening in a timely manner.
Currently, so with the two-step process, so in that situation, the housing provider would have to send that tenant a termination notice for breach of lease, saying you're in violation. That's a 30-day notice. So we're 30 days out. The court process is then the next step to enforce that notice, assuming the tenant didn't leave or the person that was there that wasn't supposed to be didn't leave. The court process right now is running 4 to 6 months. The court clearance rate or clearance parameters for these types of eviction cases is 6 months.
Thank you so much.
Oh, you have a question?
I do, some of which you just answered. The first question, thank you for joining us, by the way. You mentioned there are about 75,000 rental units
Yes.
statewide. Do you have any numbers indicating whether that is trending up, trending down? And I'm trying to suss out how much of the current crisis is supply dwindling or demand rising or both.
So those numbers come from the census. So we're always behind in that regard.
All right.
But I think
But
if what I've been seeing is correct with the level of development that is sort of happening right now, I think we're seeing an uptrend in units, but we have not kept pace for a very long time with the number of housing units that were needed in the state.
okay. Is there any, to your, and this may be a census question, it may be a municipal appraiser's question. I'm trying to get a sense for how many single unit or accessory dwelling units exist that could be in the rental market if people were more confident if the landowners were more confident in the rental process, how much that might address some of the backlog. Do you have any sense of what those numbers might be or where they might come from?
I don't know what those numbers would be. There's a couple of sources. The census data may have some of that if you dive down into it further. The other place that may have that data is the tax department. There has been some collection with the landlord certificate filings of rental units and number of units. But it's not the easiest data to get a hold of from the tax department.
Laura, did you have a question?
No, I was just trying to clarify, so the data that we have, because, so it's from 2020, which is a really weird year for gathering any data. Yeah.
Correct, correct.
Go ahead, you have another question?
I have a bunch, yes, I do.
Please,
Thank
go
you.
ahead.
I've heard a number of different people speak to landlord tenant situations where the only remedy is an eviction. I'm curious to know from your perspective, what would another remedy look like?
I think eviction is the remedy that we have for dealing with the end of this relationship. That remedy could be changed, right? Most states have some sort of process that landlords have to go through to have somebody removed. There are a few states that will allow a landlord to send a tenant a notice. So like step one in our process, and then the landlord can take that notice to the sheriff, and the sheriff will just show up and remove people. That there's sort of two extremes there. But we do have process, and we do have due process. I think there could be room for something that looks different, that still provides people notice and goes before a judge that's making a decision, but that is not this lengthy 6-month process that takes a lot of time. Is it something like housing court? Is it something like Massachusetts does, where they have a very summary process for possession, and then everything else gets dealt with later? There's a number of different models out there that could be looked at if the legislature was interested in making, or this committee was interested in making some changes.
Thank you.
I guess I have a question somewhat similar. It's related. I'm wondering what your thoughts are about whether anything could be done short of just huge application of huge amounts of money for more personnel. It would really substantially shorten that 6 months.
It's possible that moving all housing cases into one docket could. So you have, 2 or 3 judges that's all they do is housing cases, similar to what environmental court does currently. That would free up, the rest of the civil docket. I think there are some timeframes in civil rules. If you make a housing docket, could they have their own set of civil rules that are different from what the rest of the civil cases have? Some of them, it's procedural stuff that could change related to timing. How much time somebody has to respond to something. Are they able to ask for a jury trial? Do they do discovery? Can they, push cases out? Could you set parameters where housing cases filed, status conference in 30 days, final hearing in 60 days? There could be timeframes added in to process that directs the court to handle cases in a certain way.
There are proposals. Do you think general proposals that housing cases take precedence would have any effect?
My understanding is that the civil courts, for the most part, try to handle these cases as expeditiously as possible. They're doing the best that they can. What we run into in some courts are in our multi-jurisdictional courts, and for folks who don't work within the court system, we have courthouses in Vermont where the civil, criminal, and family court are all in one court, and one judge is sitting handling all of those cases. Criminal court and family court have very specific rules for the timing, and those cases tend to take priority. So in some counties, the civil docket is sort of pushed to the bottom in terms of priority, just because of the type of court that it's in. But ultimately, it comes down to scheduling, court time, availability of judges, and getting people in as quick as they can. Probably requires more personnel.
Go ahead, please.
Yeah, thanks, Angela. I also want to let the committee know that, and I believe we've talked about this before and with folks from the judiciary, that there has been an increase, as many of us have read, in new staff that will be able to expedite things in a quicker fashion, but that hasn't started yet.
Right.
But as far as it being in meetings that we've had, many of us, myself and folks on the Judiciary Committee, we have talked about with the judges giving that direction, but there isn't something currently in statute or that we've directed from the legislature to enforce that. But we do expect, and we can do something about that, but we do expect that there will be a difference moving forward because they have increased the staffing there, which was one of the things that the legislature worked on last biennium, was to increase
You mean the appointment?
the judges. So
Right.
we did put fiscal money, we put money behind that so we could hire more judges. And it is my understanding from meetings, and we can have Terry in again or others, that we will start to see a change, but currently there is no mandate direction of green light this or move this faster.
Right. That's my understanding as well, as this is the first time in a number of years that the judiciary has had all of the judicial positions filled.
Right.
Yep.
So I am expecting that to make a difference.
One of the things we've heard about a lot, I'm sorry, did you have a question?
Go first.
Is the whole issue of for-cause evictions versus no-cause evictions.
Yeah.
Somewhat to my, and I've heard different things. On the one hand, I think we've heard landlords feeling that the no-cause eviction is essential to them for various reasons, including the difficulty of proving cases for cause, particularly bad behavior or drugs.
Yep.
On the other hand, I think we got data which showed that by far the largest percentage of cases were for cause cases, that is non-payment.
Yep. Yeah.
Just they were non-payment. That it was like 3/4 of the cases were non-payment. Which is it? If most of the cases are for cause, why is no cause so important? And is there any sort of solution to that conundrum that occurs to you?
Right. So with the no cause, and I think it's confusingly named, because really what a no cause notice is a non-renewal of lease. So a no cause notice is not something that a landlord can use in the middle of a year's lease. So it's not something a tenant's getting 2 months into a year's lease. It's something that the landlord could, as that term is coming to an end, say, I don't want to renew your lease. It's time for you to move. And there could be a number of reasons for that. Sometimes landlords have other things they want to do with a property. Sometimes that tenant hasn't been a good neighbor. Sometimes there's been, habitual non-payment situations. And so landlord just wants to make a change. So this fear that like tenants can be asked to leave whenever with this no cause notice is actually not accurate. If tenants are on a lease, they're in a lease and everybody has to follow that lease. but at the end of that lease, the landlord could use that. I see landlords use that no cause notice at the end of a lease or with a tenant that is on a month-to-month lease in these situations where they can't fully prove that there's drug activity, where somebody is being a very bad neighbor, maybe harassing other neighbors or causing challenges within the building. Those types of allegations require those other residents to participate in that process. So one of the reasons why landlords are so protective of this no cause notice is that it allows them to deal with a problem in their building without having to involve all of the other residents in that building. And sometimes there's a significant safety issues for those other residents who are making those complaints. Keeping in mind, this process is so long. So you make a complaint to your landlord about the behavior of your neighbor. And if the landlord doesn't have the ability to use that no cause notice, the landlord has to provide a detailed description of what the behavior is, who told them, when the incidences were. Now the tenant who has engaged in that behavior knows who told the landlord. That tenant has to live next to that person or in the same building with that person for months on end while this eviction process goes through. And it can be incredibly dangerous for folks, particularly if they're making complaints about suspected drug dealing, suspected drug dealers moving into the unit, tenants who are being really aggressive with other residents, threatening other residents. So that's when I see landlords using no cause notices. And they're using it to protect other people in the building.
Any questions?
Yeah, several.
Thank
So-
you.
Thank you. So, the things that you were just listing sound like causes to me. I have a couple of things, but I gotta go in reverse order because that's where my brain works. So I'll try to get back to my original question if I can. And so I'm curious because I want to reiterate, make sure I'm hearing correctly. So, and what I'm hearing you say is that landlords currently, I'm not going to say do not, because I will say I know of several cases where landlords have in fact evicted people 2 months after signing a year lease, midway in their year lease, et cetera. So with a lease and still eviction, and for no cause. So that does happen. I'm just curious, are you saying that that is not legal, that happened?
So that shouldn't have been a case that made it through the court system. Were those situations that went to a court and a judge looked out, or were those situations where the
No.
tenant received a notice and then moved?
That's what I'm saying. So, but currently, I'm talking outside of the court, because my follow-up question is going to be, is this only applicable through the court system? Because if landlords are using this to their disadvantage to tenants who are unbeknownst, who don't know,
Mm-hmm.
that's what do you see what I'm saying? So the
Yep.
language that is there, because you said, it's a non-renewal of lease, but there are people who have leases, who have received notices, who have then gone through this process, not through court, because then they follow the orders. And so the second part of the question for me is, a lot of what I'm hearing is from problematic behaviors, which would be cause for eviction. And so I'm confused as to why there's so much confusion between no cause and cause. And I understand you're saying that other people would have to be involved. However, are there not ways, because I'm going to circle back to Rep. Charlton's question, because I have a similar question to reiterate in another fashion. Is there not ways to have people be evicted, or not even be evicted? Because like this is, I think for me, it's less of the eviction stage and more of the process. And let me jump back to my first question now that it just popped back in my head. Thank you. the process, you had asked if there's an alternative, right? And so when you gave the definition for the alternative, it was like, oh, or another alternative is they could write a notice and the sheriff could take it and then remove the person.
That's other states, a few states
Other
do,
states.
Okay,
not most.
so, but either way, the alternative is removal of a person. So all we're talking is, I'm curious as to, the primary conversation is removal of people from properties. That's what we're talking about. Like, this is not about landlord, or 10 other issues. It's about what ways and means can people use to remove people from properties?
Well, if we're talking about the eviction process, that is what the eviction process is.
Right, right. And so, but what I'm saying is the alternative would to not be, I guess that's where I'm confused.
Sure.
Is eviction the only alternative to any complication with a landlord? I guess that's the question.
That is the only remedy available to landlords for dealing with a situation is an eviction.
If they want them out, yes.
Yes.
I guess that's what I was gonna, I guess that is a better question is, do all landlords just want people out? The narrative, the language here is causing my brain is
So
trying to.
landlords don't want to do evictions. Can I just be clear? Like, they are not happy if they have to do an eviction. That's a very bad business model for them. They want tenants who pay the rent, who respect the property, who get along with the neighbors. They don't have to like the neighbors, but, have a community and a property that's sort of not in chaos. Evictions are used because there's no other alternative for asking somebody to move, and it's not the place the landlord wants to be. That's the relationship is broken down. Something is not going well. That is sort of the end exit strategy because there's nothing else that's going to fix whatever this problem is.
Okay, thank you. So I'm just trying to, because I just want to come back to the other question of the no cause versus just cause in the language. Either way, there's a problem that is causing the landlords to want people to leave the property. So that's why I'm still hooked up on why the language of the no cause and just cause, but I digress. So I will let you continue. Thank you.
I guess though, I do want to pursue your question a little more while we're waiting. I guess we still don't have our 2:00 witness quite with us yet. But I'll tell you what, Linda, well, you could send her an email perhaps and just let her know that when she gets here, we're ready for her. But we could.
I mean, if you don't mind, I would just jump in and say, by the time the landlord sends the tenant a notice, so if there's been ongoing problems there, we've seen, direct outreach by the landlord. So if it's a rent issue, they've followed up, they've phone calls, they've emailed, they've perhaps gone by the property. If it's a behavior problem, there have already been, phone calls, emails, conversations, attempts to just be like, hey, you informally first, you can't be engaged in this behavior. It's not, there's one incident and, I'm gonna go to eviction. Like, usually there has been a huge amount of effort and attempts to communicate and solve this problem with the tenant before we even get to an eviction notice.
Do you think, I guess my question is, in the situation you described, where there's behavior going on, I'm not talking about non-payment, where there's just behavior going on that is unacceptable, and the landlord's problem is getting anybody to corroborate that because people don't want to do that. Have you thought about any other, I've thought about this, and I'm just wondering if you have, whether there's any other procedural or legal device that we could invent or think about that would deal with that situation in a more effective way. The reason I mention that is that nonprofit renters, the nonprofits that rent, have
authorities.
repeatedly expressed frustration over unsafe conditions that they can't deal with. And I'm wondering, you think there's a solution?
Well, I think our solution has been this no cause notice, as much as
Yeah.
people don't like it. And interestingly enough, in the nonprofit world, they, under their federal funding streams, can't use that notice. So we sort of see these increased levels of chaos in some of these properties because they have to do the very thing that I'm talking about. They have to prove, they have to drag neighbors in, they have to, have other tenants that are involved. And it is not a very fun situation for anybody in those properties.
That's a question.
Please, okay, and then this will be the last one. Thank you, by the way, Angela, for
Yes.
coming, and I know we'll be back in touch.
I would say I'm happy to come back.
I am trying to thread the needle between what I hear from constituents. I hear from landlords that are facing these very real issues. And I hear from many renters who face the issue of, I got kicked out for no cause at the end of my lease, but I essentially am facing eviction. After my 1-year contract was up, it went to a month-to-month lease. And a month-to-month lease means that at the end of every month, my contract is over.
Yep.
And I can be asked to, it leaves open the possibility of not having my lease renewed.
Mhm.
And that is a huge instability in the lives of renters in our state when there is such a housing shortage. And so I would love to get solutions proposed that thread the needle between providing stability for our renters and a fair system that doesn't allow people to have to leave, families to be uprooted because they can't afford a better rent at their home. And unless the contract is over, you can't increase their rent past a certain amount, right? Am I right in asking? Is
So-
that true?
So we are
Is there a
talking
cap?
about, there's not a cap. We are talking about a contract between two parties. So
Yeah.
what you're describing is one solution here is there's nothing to stop the tenant from going to the landlord to say, hey, I'd like to do a lease renewal for another year. Can we do an addendum to the lease and sign for another year? There's nothing that prohibits a tenant from making that ask of a landlord. No different than a landlord coming to a tenant saying, let's do another lease renewal. And for a lot of these folks, it's an issue of nobody's paying attention to the paperwork. The landlord's not, the tenant's not, they're there for a year, the year's lease expires, it goes to a month, and nobody's concerned about that until the tenant gets that notice saying, hey, it's time to go. I'm not renewing for no cause. There could be a level of proactivity on the side of the tenants if they're wanting to stay there longer.
But if the response to them is, sure, you can renew, but now your rent is gonna be this much more, and you don't have that full year, do you not have less time to, until the end of your contract,
You
like
do.
notice, are you given the same amount of notice, whether you're in a month-to-month or in a years-long lease?
So if you're in a years-long lease, the landlord is not supposed to use that notice till the end of that year. But the amount of time they have to give you before the end of the contract is the same as folks who are on a month-to-month. So the statute doesn't distinguish between years leases and month-to-month leases. It just says at the end of the lease term, for tenants who have lived there less than 2 years, it's a 30-day notice. And if they've lived there more than 2 years, it's a 60-day notice. So it's tied to length of time. So if a tenant's lived at a property for a longer period of time, they get more notice.
Even though
regardless
the
of what-
contract
It doesn't
is,
matter whether
so,
it's.
so that
either lease or a
obligation
30-day.
outlasts, yeah, so that obligation outlasts your contract
Right, it does.
by 2 months.
In other words,
Okay.
as I understand it, and then
How-
let's
how does
stop, as
that
I
fit?
understand it, it doesn't matter whether on the very last day of the lease, it doesn't matter whether it's a year lease or a 30-day lease. What happens afterwards on termination is the same.
Mhm.
In each case, people have to be given a notice to leave, which is if they have 30 days, if lived there
2
less
years.
than 2 years, and 60 days if they've lived there
2
more
years.
than 2
More.
years.
Yep.
It doesn't matter whether people just forgot and they're on a 30-day, and they're on a month to month, or whether they're in a lease and the lease is over, it's the same. Angela, thank you so much for coming. I can
You're
tell there's an appetite for more. And so I have a feeling that we'll be seeing you again. I appreciate it. Joe?
And I would be happy to try to come in person next time.
Joe, you get the last word.
Not a question for you, Angela. You're good to go if you'd like, I guess. It was just a statement of what the conversation that was just had. 4 years ago, the now chair, Rep. Byram, made this exact point that where's the outreach to all the tenants from all the word salad of organizations we have, letting them know at 10 months, you should be reaching out to your landlord. Where's the notice that they get every time you contact somebody? Hey, reminder, 10 months, you're looking to re-up your lease with your landlord. And the answer back then was, we don't do that. We're like, well, you should. And we're here 4 years later, and I'd be curious to know how many of the housing organizations have that letter or say, yeah, here's how we do that outreach.
I strongly suspect that they have no finger on all the 76,000 leases or however many there are.
No, I'm just saying, like, anytime they have contact with somebody,
Yeah. Oh, okay.
anytime there's a contact, it should be, hey, just remember, 10 months, be looking to re-up a lease so that you don't go month to month.
Advice to tenants.
Right.
Thank you very much, Angela.
Thank you.
Stay well.
Thank you very much for having me.
Okay.
Thank you.
John.
Thank you, everybody. I'm sorry if anyone here feels like I cut you short in your questions, but I think we will probably be continuing to discuss this issue and look for solutions that so far have eluded us. Our next hearing is we are going to hear from the Vermont Human Rights Commission from the executive director, Big Hartman, who is executive director and general counsel, and they will give us their testimony. Big, do you know everyone here? Should we introduce
I
ourselves?
don't know everyone.
I think we should go around and introduce ourselves. You want to start?
I will. Good afternoon.
Hi.
Sadia Lamont, Memorial Washington District.
Great to see you.
And Mary Howard, I represent Rutland City District 6.
Gail Pezzo, Chittenden 20, Colchester.
Hey, Tom Charlton, Chester, Athens, Grafton, and Wyndham.
Joe Parsons, Newberry, Thompson, and Groton.
Lenore Dodge, Essex Town and City of Essex Junction.
Actually, Bartley, Fairfax, and Georgia.
I'm Mark Mahaly, Plainfield, Marshfield, and Callis. Welcome. Please state your name for the record and then take it from there.
Okay, great. I'm Big Hartman. I use they, them pronouns. I'm the Executive Director and General Counsel of the State of Vermont Human Rights Commission. Thank you so much for having me today. So it's been a really busy year since the last time I was talking with many of you. I was thinking about kind of giving you a rundown of general information about what the Human Rights Commission does, and then review some of the data from our annual report, hot off the presses today, and address any questions anyone might have about our work. How's that sound?
Fabulous.
Okay, great.
Joe's really excited.
Kinda am.
This tends to be like the time of day that we're all getting a little sleepy. So it's like watching some comedy or something to keep us all engaged. Our agency is tasked with primarily enforcing Vermont's Fair Housing and Public Accommodations statute, which is our anti-discrimination protections for housing and places of public accommodation. So housing discrimination can occur when by landlords, property managers, condo associations, even neighbors can be found to have harassed another tenant or another neighbor. And in places of public accommodation, we're talking about any place that is open to the public. So any kind of business, shop, hotel, but also state agencies, municipalities, parks, and any schools. So those are the bulk of our cases involving those two types of claims, but we also have a small portion of the employment discrimination complaints that are just made by state employees. The rest of employment discrimination claims are handled by the Attorney General's Office Civil Rights Unit, but we just have jurisdiction over state employee claims against state agencies.
Big quick question. Is an organization that's private, like a school, let's say a private school, in your experience, are they considered public accommodations, even if they take the position that the only people who can come in are either members of the school community or other people who are given permission?
Our definition of place of public accommodation is extremely broad. It expressly says any school.
And it just says any school.
Any school. So we would absolutely believe that we have jurisdiction in that type of place. So we enforce those laws first by processing complaints of investigation that our office receives. We have a team of a mighty three staff attorney investigators who are conducting all of the discrimination complaints that we receive. This involves in-depth investigative interviews, review of documents, sometimes site visits, and then at the end of their investigative process, they write an investigative report that summarizes the interviews that they conducted and analyzes the law, making a recommendation about whether or not there's reasonable grounds, that's the legal term, to believe that discrimination occurred. Our investigative reports are shared with the commissioners. We have a commission of 5 governor appointees who serve 5-year terms. You had in here our chair last week, Coach Christie, and they hear the cases once a month. They conduct very informal hearings, giving the parties opportunities to say why they agree or disagree with the recommendations. And they make final determinations in public session about whether or not a case has reasonable grounds or no reasonable grounds to believe that discrimination occurred. The next way that we enforce these laws is in cases that have gone reasonable grounds. We have statutory authority to enforce the statute through lawsuits in Superior Court. Human Rights Commission is the plaintiff in those cases. We do not represent the person who was the complainant. We represent the public interest in our agency. And as some of you may know, in fiscal year 24, we started a new position. We were given a new position in the prior legislative session that is a litigator who's able to now handle all of those cases in-house. And we have seen our enforcement actions increase substantially in just one short year of having that position filled. So that's the overview. And let's see where, yeah.
Could you give us a sense numerically, how many, like in 24, about how many investigations, take us through the same triage. How many investigations, how many times did we find reasonable grounds? How many cases were filed?
I have some charts for that.
Wonderful.
Okay, so
Not everybody has your.
I have some extra copies if there's anyone that wanted one. I'm old school, so I get them printed out because
Okay,
I like.
I think you better pass.
Okay, I can see if you are in here, but
like one.
You want it on this one?
It looks like we might have enough for everybody.
We have,
I have it on my computer.
Yeah, it was shared electronically.
But I made 6 copies for the people.
right, I'm wondering whether, just to assist her testimony for people who are not following, who are following online, whether we can get this up on the screen. Is that something we can do?
Yes. Thank
So
you.
while she's working on that, go ahead.
Okay, I know I'm so old school. I haven't ever actually shared my screen in any testimony yet. I've avoided it. Just a whole nother thing to look at and deal with. But I am gonna direct you to start on page 10. And this is a bit of an overview, and some of the additional data about these cases is contained in the next few pages behind that. So this year, as I was director for the entire fiscal year of 24, I really pushed us to streamline a lot of our processes and simplify our investigative report writing so that staff could spend more time conducting investigations and less time writing reports that would slow down the conclusion of the process. That was successful. So we were able to have 33 cases, that's like the third field down, determinations by the commission. 33 determinations occurred in fiscal year 24. That's a 74% increase from the fiscal year before. Because 10, sorry. And out of those 33 cases that had determinations, 22 of them were found to have reasonable grounds. This is a substantial increase from the prior year. In fiscal year 23, we had 19 cases have determinations and only 10 of those went reasonable grounds. So we're seeing both an increase in the overall number of cases that had determinations and an increase in the percentage of those that were reasonable grounds. And as you look further down at the bottom entry under there, there's a little bit of a breakdown of our reasonable grounds cases and how many were based on fair housing claims, public accommodation claims, and employment claims. And what are the legally protected categories as well. Up at the top of this data, I want to highlight for you that we accepted a record number of new complaints in fiscal year 24, up 39% from fiscal year 23. We accepted a total of 57 complaints for investigation. 35 of those are housing. That's double the number from the prior year. And this really has been where we're seeing the bulk of new requests for complaints are involving fair housing.
Just clarifying this, sorry. So you have, here we have 57 complaints and then further down we have 22 reasonable grounds. So are we saying that it was less than half of the complaints that came in were found to have reasonable?
So,
Is it different?
yeah, a little bit different figures there. So the top number, the 57 complaints, those are new complaints that we accepted. Very few of those had determinations this year because it takes much longer than that to finish an investigation. So the 33 determinations were primarily cases from prior years that were older. Okay, and so what you're seeing though is that we're closing, including settlements, we've closed 43 cases, but we have 57 new ones. So we're just every year, and that's the data every year, that there's more cases coming in than we're able to close, and the backlog just builds and builds every year. But I don't know that I addressed your question.
So you had 57 complaints. Of that 57, how many you still in the process of finding out whether they have grounds to?
Yes, it's possible that certainly some of those cases would have settled by now or had determination. I don't have that data for you for today, but I can certainly check on that. And I will say already this year, we have over in fiscal year 25, we have about 33 new complaints accepted and initiated.
But I want to go back to what you just said a minute ago in the answer to the question that was asked. So as I understand it, I'm going to try saying it. In 24, 57 complaints were filed. 33 determinations were made, of which 22 were found to be reasonable grounds. But the problem with comparing 22 with 57 is that, in fact, there are a substantial number, some substantial number of those 57 simply weren't resolved. They didn't get to the point of reaching a conclusion about a determination in 24.
Correct,
They're still hanging over.
correct.
That's what I wanted to say.
Yes, and I do want to talk a little bit about case age, because I don't know if some of you recall last year, I was in here griping about our average case age at closure, because I did not feel it was at all acceptable. That what I found in the fiscal year 23 data was that the average case age at closure was 649 days, which is almost 2 years for people to wait for some closure. That, and we're talking about, especially with fair housing cases, we're talking about an ongoing situation. You've been denied housing, you're in a hostile housing environment. This is something that is pressing on you every day, and you're waiting for the Human Rights Commission at least a year, often 2 years, for some kind of closure. And that is really hard on those people, both the complainants and the respondents involved in those cases. And it's extremely hard on staff. We feel that stress. We feel that pressure to get these cases closed for these folks, and are just not able to get ahead of that at all. But because we did streamline a lot of our investigative report writing process, we did significantly improve our case age. And that is, there's a bit of a chart about that on page 13. And it's summarized in some of the narrative above. So this year, so I said last year, our average case age was 649 days. We got that down to 474 this year. That's an improvement. We're very proud of that. That is only because of our hard work and our commitment to innovating and improving our processes.
Sorry, down to 474?
474 average of all of the cases.
Yeah.
And I thought it was interesting to see the bar graph on page 13. You can see the housing cases we close the fastest on average. The public accommodations cases are, you know, in the mid 500 days, and the employment cases take the longest. And are often not as urgent an issue, right? Someone's out of the job. And so we're gonna hopefully remedy that if we find reasonable grounds. But the housing cases are still averaging more than 1 year. And this is a real problem for us for a number of reasons. In addition to that urgency that all the parties feel in those types of cases, we have a HUD contract that enables us to receive funding for processing fair housing cases that are that implicate both state and federal law. We get paid per case. We have certain performance measures that we're supposed to keep up with for HUD, which we have not historically been able to keep up with, and we certainly are failing this year. They're still giving us an okay score, but it's very concerning to them that the expectation is 50% of our cases are going to close in 100 days. We did not close a single case in 100 days. And often our intake process can take 100 days because we don't have a full-time intake person. It's a duty that's shared among myself and the administrative position in our office. And it is a constant influx of new things coming in and trying to, conduct intake meetings in a timely fashion with folks, gather information needed to see whether we can accept a complaint for investigation and what it should say, because we draft those complaints for the parties. So,
Okay, good. One question. If you go to court and you win, what do you win? What are the actions that you can get out of the court?
So we have a full range of remedies available under the Vermont Fair Housing and Public Accommodations statute. And these range from individual relief for aggrieved parties, injunctive relief, where a court would order respondent to do a certain thing, or stop doing a certain thing. And then also we can be awarded civil penalties and even punitive damages, although I'm not aware of an instance where punitive damages have been awarded.
How about compensation?
Yes, and we can also be awarded attorney's fees under that statute, as can anyone who has an attorney in those cases. But yes, it's individual relief for the aggrieved party, compensate them for losses or pain and suffering and that kind of thing. Often our litigation is resulting in settlement. And we consider that, a good outcome. Not everyone, it's not healthy for everyone to go through a jury trial about the discrimination that they've experienced. And if we can solve the problem, and our settlements that we are involved with will always contain some type of public interest relief, that's what we call it, something that's going to help us feel like this isn't going to happen again. So oftentimes, especially with landlords, we're talking about, it's time for you to get some fair housing training. It's time for you to institute a reasonable accommodations policy. Let's get a written statement of non-discrimination, something proactive that's going to help us feel like this person isn't going to engage in this conduct again. Just to go back to the topic of case age, under our rules, we are supposed to close our cases within 6 months or at the very longest at 12 months. We are really not able to keep that standard, and it is definitely, all of the staff feel a pressure to finish our cases as quickly as we can, but we're not going to be cutting corners on our investigations to do that. So what is happening is a very intense level of burnout is occurring in our staff. Beyond normal staff turnover, I have seen in just the 3.5 years that I've worked at the commission, out of our whole team of 7, I have seen 7 people leave. And that is people who love this work, who love this job, who are committed to civil rights and cannot take it anymore. And just cannot keep up with the constant new cases coming in. The reward when one of my investigators closes out a couple of cases in a month is, here's a couple more cases, like, actually, here's more than 2, it's really a heavy burden for all of us. And these are, and at the intake stage, these are folks calling us in crisis, trying to talk to us about something extremely traumatic that they've been through. We're trying to give care and compassion and time with those folks and attention. So it's not a re-traumatizing process for them to come here and tell their story again and again. And that can be extremely draining on staff. So historically, it's just been the executive staff assistant, the admin position, fielding all of those inquiries and intakes. And I was seeing the revolving door of that position happening, where folks just can't last doing that work, especially for being at pay grade 22. And so this year, in order to kind of spare my staff, it's a
How much is that
pay grade work? The salary is in the low to mid 50s.
Dollars per hour or
No,
thousand per year?
Yeah, 50,000 is the salary position.
Yeah. Thanks.
So in order to help the new, that position turned over this summer. In order to support the next person coming into that role, I started taking on intakes. I started answering the phones just to try to, not overwhelm somebody coming in again right away. And, that is, we're just kind of in a crisis triage mode every single day. And I have no choice but to decline to take new investigations on a daily basis, it feels like, because I cannot overwhelm my staff. And I have a stack of new complaints that we've accepted that are processed, and I am not assigning an investigator to those cases. They've been waiting for about 6 months for an investigator to be able to have time to start looking at them. And it is, in my opinion, a real problematic situation. And we had another investigator, our most senior investigator, just leave because of burnout this winter. And when one person leaves in our office, it leaves this huge void. Someone leaves, there's 20 cases on hold. That's a third of our caseload on hold, waiting to onboard somebody new and train that person. That means all of our cases are going to just be slowed down again. So that's why I know that it's already been introduced, the new H38 to in a way, sort of double all the staff that we have. Like if every single person in the building was replicated, we would actually be able to manage the workload and be able to accept the level of complaints that we're receiving. Just this week, Monday, there was an article about a settlement in one of our cases in VT Digger. So that meant Tuesday morning, there's 20 new calls and emails for people who want to file complaints with us. And I haven't gotten back to those people. We're still trying to close out the cases that we had a commission hearing on Thursday. You know, we just do not have the capacity that we should have to be able to do robust civil rights enforcement. And this is just, you know, I was just at a panel last week with other HRC directors from the other New England states. And we were all asked a question about how are we preparing for the next 4 years of likelihood of increased civil rights violations? And all I could say is we are not prepared. We are still dealing with last year's civil rights violations and the year before that. We are not having the capacity to proactively address, you know, potential civil rights claims, let alone just like deal with the day-to-day cases that are coming in every day. And the community is losing some faith in us when we deny them because of capacity. When we say we cannot accept your complaint because you're alleging novel or complex issues, you know, this case is going to be years for us to finish. Like I can't accept a new complicated, complex, systemic case right now because there's absolutely no one to do that investigation. And it's really heartbreaking. It's really, we're really in a tough situation. Despite all the innovations we've made and the improvements to our processes, it's just not enough. So that's why, you know, I'm over here devoting more time than I really have to working with policy leaders and legislators to see if we can get ahead of this just a little bit for this fiscal year. Really grateful that your committee was willing to support our BAA request for some new positions, like starting right away. If I had a new intake person today, I would be able to assign them 40 phone calls to return. Like I can't keep up with the phone calls and not even to mention the emails. And then if I got an investigator, I have a huge stack of new complaints they could investigate tomorrow. You know, instead, I'm waiting for our older cases to close out to then assign these old ones, and the new ones just keep coming in as well. So we take as much as we can, but it just doesn't feel like enough.
Commission questions, yes, committee questions, go ahead. And then Joe.
Thank you for explaining this. I'm trying to understand your wheelhouse as opposed to Vermont Legal Aid.
Sure.
And help me figure out why would, because if anything, all of the things that are going on in our state, that caseload almost looks small.
It does.
To my mind.
Yep.
So if people are seeking legal remedy in many ways in this state, where do you all fit in exactly?
So legal aid sometimes will provide representation for a complainant in a case. They represent the complainant.
Right.
In our cases. And we don't represent anybody. Right. So we're having to work with the complainant and get their information. We're working with the respondent, getting their information. We're interviewing third parties. We're gathering documents from any sources we can. And we're conducting an objective investigation where we are not representing anybody. And we are able to facilitate communications between those parties. Usually they don't want to talk to each other, or it's better if they don't. But we can be sort of a middleman for those conversations to see if we can find a solution. But it's not the same as having advocacy for one person on their one issue. And oftentimes legal aid is referring new cases to us. We're representing this person, or we did an intake with this person. Here's their facts. You know, can you please consider this for an investigation? A lot of times people are calling us, we're getting through an intake process and we're saying, what you're describing is a landlord-tenant dispute, not discrimination. You could try your hand with Vermont Legal Aid. Maybe they can help you. Maybe CVOEO can help you. We provide a lot of referrals for a lot of the issues that come through our door aren't necessarily discrimination that's going to fit in our jurisdiction. there are many discrimination claims that have come through the door that I have said no to because we just don't have the bandwidth. But yeah, it's definitely a different structure in we're not giving legal advice to anybody and we're not representing anybody, which is what legal aid does. And most people don't have attorneys in our cases. A lot of landlords do, but most complainants don't. And if they do, the only representation they have is with legal aid. Primarily.
Joe, did you have a question?
Yeah, I kind of either went right over my head or I was reading something here, but the HUD expectation,
Yeah.
like 100 days. What's like a little background to like, what's that connection with you and HUD and?
Sure. So about 10% of our funding comes from HUD through a contract to do fair housing investigations. So any case that we get that's a fair housing case that also implicates the Federal Fair Housing Act, we can accept the complaint and then dual file it with HUD. And then HUD will let us do the investigation. And if we find reasonable grounds, HUD finds reasonable grounds. They pay us for each case that we process that's dual filed. It also works the other way. HUD will do its own intake. Someone will contact HUD. And if they allege something happened in Vermont and it meets the jurisdiction of the Fair Housing Act, HUD will refer that case to us. And then we are the only investigating agency. HUD does not do its own investigations of fair housing. They contract with us to do that.
Okay.
And they pay us per case, and they also pay us like a sort of baseline administrative cost. It's not that much. It's under 100,000 historically. The more cases we close, the more we get paid for those cases. So I am hoping that with the creation of new positions, we will be able to increase our federal funding, assuming HUD funding doesn't go away for some reason.
Okay. Does HUD contract with others in the state of Vermont to do that work?
No, we are the only entity. Yeah.
So for other states, there's a single entity that they,
I think in other states, like in Massachusetts, there's a Massachusetts Commission Against Discrimination, but then they also have like a Boston Human Rights Commission. So there might be local, what they call FAP agencies, Fair Housing Assistance Program agencies, that all have the same type of expectations and contracts with them. But in Vermont, there's no municipal HRC. There's only us.
okay. And so every state has somebody they contract with, and larger states assumably have probably multiples for each.
New
larger
Hampshire does not have a FAP. So the New Hampshire HRC does not investigate fair housing HUD cases. HUD does that, is my understanding. They at one point were the FAP, and at some point that contract ended and they did not renew it. And I'm not sure whether they're planning on trying to get that back or not, but they're sort of the anomaly of most places have a FAP that is certified through an extensive bureaucratic process to get approval to process for housing cases.
Okay. So
I
if
spent a lot of time with HUD. Yeah.
so if I were to, so if there was like a, none are going to be apples to apples, but similar, maybe different varietal of apple. If there was other states to compare ourselves with as like size of the commission, how much work we're doing, that type of thing. Who should we look at for, you know?
Maine might be the closest, and I am always having those conversations with with my counterparts in other states because I'm geeking out. Like, what does your statute say? What are your expectations? What do your investigative reports look like? Everybody has a different statutory system. A lot of the other New England states have commissioners who are employees who actually conduct administrative hearings or oversee investigations. Our commissioners meet once a month. They get a small per diem. They're not part of our day-to-day operations. So it's not always apples to apples. And also they have different areas of jurisdiction. Almost all the other regional in this region in New England, all the other HRCs have all of the employment cases under one agency, not the way Vermont does it, where we have this civil rights unit of the Attorney General's office separate from our office. So when you look at the numbers of other cases, the number of cases that they have, it's going to be way bigger because it includes both of our agencies. Yeah, comparable.
Okay.
Thank you.
Thanks.
Any other questions? Yeah.
You had said that litigation typically results in a settlement. Can you tell us what that looks like?
What a settlement looks like? Sure. So oftentimes in a good settlement, we see some individual relief for the person who was harmed. They're not often like big settlement dollars, but
So then you are advocating for that particular person.
it's a really fine line that we walk. And oftentimes folks will have, once they get to court, because we're not representing them, they will have their own lawyers
Okay.
who are helping them in their settlement process and advise them like, what does this general release mean? And that kind of thing.
Okay.
So, but not always, and it is really tricky. They are desperate for legal advice and we cannot offer it because we just represent the agency.
Okay.
But a good settlement results in both individual relief and some form of public interest relief, something that's going to make us feel like you're not going to do this again. It almost always includes a general release, a promise not to sue, and a statement that I admit no wrongdoing by the respondent, right, by the defendant. And then there's sometimes monitoring that happens. We want to see how many applications you get in the next 6 months and how are you, we want to see you give priority to certain types of applicants. There are some other kind of creative things we can come up with to help us feel like the public interest relief piece is satisfied.
Thank you.
Are there other questions? Ashley?
Hate to bring it back to HUD, but I'm going to. And maybe I missed it. So HUD provides funding per case. Is it per case or per housing case?
Fair housing case that is also protected under federal law.
Okay.
We have a few legally protected categories under state law that aren't protected under federal law. I can't dual file those.
Okay.
The most common one is receipt of public assistance. So a landlord can't say, I'm not going to rent to you because you get Social Security. But that would only be a fair housing case under state law, not also under federal law. So HUD won't count that. They won't accept it for dual file.
I'm just going to ask it anyway. I'm like having a hard time putting the right words to it. Do you weigh cases on like, not what's the easier or better case? Is there a way, or is it like first come, first serve? I guess is the best way to.
Prioritize.
Yes, thank you.
How do
Prioritizing.
you
It's
prioritize?
late on a Wednesday.
I had
Yeah.
that same question.
It's really tough. We don't have any rules to follow here. This is really like what makes sense in a situation. When I first became director last fall, I took every case, right? I'm like, I'm just going to take every case. And then I started to realize, this isn't functional, right? I'm taking every case and it means that my staff are out of their minds and we can't keep up with this pace. So over the course of the last year, I've really had to get more selective and way more selective than I want to be, and sometimes it is about what is the burden that this case is going to bring to the office? Because if I'm going to take this one case, that means 10 other cases aren't going to go through. And I hate that. I hate having to do that analysis. But we also are guided by some of our own like staff developed strategic priorities, right? So we have enforcement priorities in certain types of claims, right? We want to be able to accept as many of the school harassment claims as we can. We want to be able to accept as many of the racial discrimination claims that we can. These are claims that we feel like people aren't going to be able to pursue their own case in court. Also, I give a high priority to service dog cases in places of public accommodation. It's a really straightforward area of the law. And I've seen people with disabilities who need their service dogs be highly traumatized by being denied access to a store or a hotel or otherwise given a hard time when they're just trying to go about their life with an assistance animal. So, it's kind of always evolving, and this is not how other agencies operate. The other HRCs that I know, they take all the cases and then they tend to dismiss them while they're in an investigation phase. We are selective at the outset, so we have very few dismissals, proportionate. I think I dismissed 2 cases last year, one because the complainant died. I don't want to dismiss a case on the merits ever. We want to have people get the opportunity to have the investigation run its course. And if it ends up having no reasonable grounds, that's what it is. But it's a really difficult situation. And when we do end up declining to accept cases, people are very unhappy with that. And they should be. You know, we're a state agency. You know, we're supposed to be serving Vermonters and not turning them away. But because it's not mandated that I take every case, you know, I exercise discretion, but I exercise it as sparingly as possible. And I would much prefer to be able to accept all of the valid complaints that come my way and then have, you know, the investigative process be fairly implemented for all folks. Even if that means we're going to see more no reasonable grounds cases, like, then that's what it should be. But I would say that's the toughest part of my work day to day and telling people, I'm sorry, we can't take your case. So we try to provide referrals, but really those folks don't have another avenue for, what are they going to file a lawsuit on their own? You know, we're talking about Vermont's most vulnerable Vermonters, very, very limited resources. A lot of folks with disabilities, folks with a lot of barriers to being able to access justice themselves through a court process.
Well, thank you very much. We really appreciate your testimony.
I have one more thing,
Yes.
which is just to share with you. One of the little things I got from HUD was a little bit of a money for a partnership grant last year. And we used that money, even though it had very little to do with housing, to create a guide for complainants and respondents, which is this handy little booklet that explains in plain language what our process is. And I have a few copies I'm happy to leave here if anyone is interested in getting a better understanding of what the HRC process actually looks like and how we try to explain it to parties.
And is that online?
Yes, it's on our homepage.
Thank you. Go ahead and pass them around.
I'll pass those around in no pressure. I'll take them back with me if you don't want one. Yes, and I do have tons more at the office. If anyone wants one, just let me know.
Check it out. Okay. I don't.
Thank you.
Oh, I do have more actually right here.
You got more there? Okay.
All right, here we go.
Sorry.
Thank you.
So just some light reading, you know, when you're bored.
Thanks so much.
Okay, thank you.
That's it.
Oh, one more for there?
Oh, I don't know.
Oh, and,
Thank you.
okay. Thank you so much.
You're welcome.
Thank you.
Have a great evening. Before we go offline, just in terms of housekeeping, tomorrow, Thursday, we begin promptly at 10 o'clock with a joint hearing with the Senate. So what I would really say is here at 9:45 at the latest.
Read this.
Yeah. You should have you should have an electronic copy of, or hard copy of the entire bill proposed by the administration. You also should have a 2-page bulleted summary that I prepared, as well as a summary that they prepared. So I would recommend reading this, at least the summaries. That won't take much time. And we'll take it from there. We do have time after lunch for committee discussion, which is just a very preliminary first round of, well, what did you think? Type thing. And which will just, I literally think I'll just go around the committee and ask everybody to talk about what their first reaction was. It doesn't have to be extensive, and people can say, I don't know what I think yet. But it's just a sort of first round. Then, you know, we're going to plunge into the issues that we've been dealing with and putting together our committee bill. What are the issues we most put in the committee bill? Then in the afternoon, after that, we have one witness, Proctor, who Rights and Democracy, statewide housing justice organization, and then we have the floor. So please be here by, I would say, 9:00 at the latest.